Hi, Commissioner Hatch. The meeting has not started yet.
No problem. I just noticed that if there are other people on the call. Hello? Yeah, without thinking of what I am.
Okay, let's go ahead and get started. Want to call roll?
Commissioner Adaro?
Yes.
Commissioner Hatch?
Here.
Commissioner Hayward?
Here.
Chair Remke?
Here. Okay, so Commissioner Hatch, can you hear me okay?
I can hear you all right. It said that there were 2 other people on the call.
You know what? I can barely understand you. Are you on the speaker phone?
Yeah. My question was, when I called in, it said there were 2 other people on the call. So I just wondered who else was remotely accessing the meeting.
Sasha, you want to address that?
So the 2 people would be the room and you.
Okay. All right.
Okay, thank you.
So, Jack, so you're in, I understand from the notice, in a lobby, and I'm going to go ahead and take a wild guess that there are no other public participants in that lobby, in which case I don't think there would be any problem for him to come off speaker and talk directly into the phone. Assuming someone were to appear, he'd obviously have to go back on speaker. Is that fair?
I think that's correct.
So did you hear that, Commissioner Hatch? That might make it easier for us to hear you.
The only member of the public here is my wife.
Well, if you want to have her sit through this, go ahead and keep it on speaker. Otherwise,
She's graciously giving up her vacation time for this.
okay, it's just because I know I'm having trouble hearing you, and I will make sure to pause to ask for your comments, but I think it's going to be important for this hearing more than usual to wait to be recognized to start talking. Otherwise, we're not going to be able to make any sense of this. Okay, so good morning, everyone. Public comment for any items not on the agenda. Okay, seeing or hearing none, we'll move on. The approval of the commission minutes. Are there any comments or corrections to the minutes from the commissioners?
I just have a question.
Commissioner Odero.
So, again, we have this great transcript, but the difference, I don't know if this question goes to you or to you, Chair, but the difference is that there's like rarely any punctuation at all in this transcript. Did something change? What happened between the last version, the last month's?
Oops, is that you, Commissioner Hatch, talking?
I apologize for that. Sorry.
Okay, so I can answer that question. As I explained last time, we had a actual transcription from a court reporter type service because we were testing out this computer program. So this is our computer program, which doesn't allow for punctuation and the like, but it's an issue of cost, which obviously to have a professional transcribe it is considerably costly, and this we can do in-house, so that's the difference.
Okay.
Any other questions or comments on the minutes? Anything from you, Commissioner Hatch? Okay, hearing nothing.
I move approval.
I second.
Commissioner Adaro?
No, but only because I didn't get a chance to finish reading it.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
This motion passes.
Okay, moving to the consent calendar, items 3 through 35. Do the commissioners want to pull any items from consent?
Yes, I do.
Okay, let me start with Commissioner Odero.
Number 14, please.
Okay, number 14's pulled. Any other items? Commissioner Hatch, you said something?
Yes, also items 19, 20, and 21.
19, 20, and 21. So we have 14, 19, 20, and 21. Anything from
And I
you?
have questions on 4 items.
Yeah, we'll get to that. Yeah. Anything else pulled, Commissioner Hayward?
No.
Okay. So as to the remaining items on consent, why don't you go ahead and start? Commissioner Hatch, you said you had some questions.
Yes, first a general question of the team. What is the difference between a streamlined stipulation and a streamlined settlement?
This is Galena West, the Chief of Enforcement. They're interchangeable. So streamlined settlement, streamlined stipulation, they're the same. We just use the name stipulation for the actual form itself and the signed document.
Okay. I raised the question because one item uses the term streamlined stipulation and everything else is streamlined settlement, so it kind of confused me.
Sorry about that.
And I also had a second question, Galena. Does enforcement regulation compliance for misleading committee names? If not, what agency does that?
Can you repeat the question, Commissioner Hatch? I couldn't hear you.
I'm sorry. My question is, does enforcement regulate compliance for misleading committee names? And if not, who does that?
Actually, we follow the certain rules that there are for, say, ballot measure committees, candidate control measure committees, committees that are primarily formed. They have very particular naming that they have to follow. But for general purpose committees, their committee names are not regulated by the act as far as, unless anyone wants to add anything.
The ones that are regulated.
Right, so we regulate according to the regulations and the statute about primarily formed ballot measure committees and candidate controlled, certain candidate controlled committees they have to have, as well as sponsor committees. They have a certain naming that they have to follow that's written out in the regulations, and then it's further explained in the manuals. There's always controversy.
It is enforcement, though, is the police on those issues, right?
Right, it gets especially tricky around the elections with the major funders and such.
I understand. I just wanted to verify the enforcement that does that.
Okay,
Thank you.
you're welcome.
Then the first question item I had was item 3. In the matter of Eric Marr, mentions in the stipulation that this is a coordinated settlement, and there's a $1,690 local fine and a $9,500 FPPC fine. How did coordination affect the fine amount in your view? Did it raise it or lower it, or
Certainly. Usually when there's a local enforcement, we take that fine in consideration as a total fine amount as opposed to looking at our fine independently. So even with, say, Secretary of State fining, we have to take that in consideration if their fines get up over $10,000 or something like that, taking into consideration with our fines as a total amount fine for the committee for the same activity. And that is the case here as well. We worked with San Francisco Ethics to see what their fine was going to be or what they proposed it to be, what ours was proposed to be, and then making sure that it wasn't excessive or too lenient.
I see. So absent San Francisco, you would have fined around $10,000 or $11,000 actually, I guess.
Yeah, it would have been more because there would have been also the over the limit gift violations.
Okay. Then, my next item of questions was number 7. Was, this may be plowing over old ground, but I just wanted to remind you that my concern, again, of the streamlined numbers. I'd just like to, this raises an issue that the pre-election report, I think, should be, when we revise this, should be about $200 plus 2%, and the 24-hour violations base needs to be about $400 with the 4%. And I appreciate if you took that into consideration when you review the.
So you'd like us, this is Chair Remke, you'd like us to bring back the streamlined memo to review it, because at this point, that's the standing adoption by the commission, the amounts and the tier for violations for each of these types of cases. So you're requesting that we revisit those, the streamlined program.
Yes, I thought I asked that happen a couple of meetings ago, but yes, I would like, I'm not saying this is ahead of any other issue, but I would like to see this revisited and make some adjustment for the levels of what I consider, heinous the violation is.
Certainly. This is Galena West again. I would recommend, if we are going to bring it back, we bring it back as a discussion item so that we can get a feel on all the commissioners and how they feel about the fines. And if we did this in January, that would be when we were presenting the advertising streamline program as well, to add to the programs, so we could do it as a package if the commission would like.
All right, so we'll bring it up in January along with the new advertisement streamline proposal, get a discussion, and then you can bring it back to finalize it based on what you get from the commissioners.
I have a question about that.
Great, thank you.
Commissioner Odero?
So what distinction are you making between discussion and, I guess, public comment? Are you suggesting we don't bring it?
No, I'm sorry. All I was suggesting was, since I don't know the majority of the commission's feel on the current streamline program, that it would be a time for everyone to discuss and talk about what direction they would like to go on the different programs, as opposed to me just bringing back something and saying, here's some numbers. You guys all agree with me, right?
Okay. And public comment would be permissible at both meetings. Okay. All right. Commissioner Hatch, did you have any other questions on the remaining consent items?
I have one final one, and that was item 35. It was a matter of Timothy O'Donnell.
What number?
And I couldn't tell from the SIP, but I was wanting to know what was the form of income from Cadway that he failed to report.
Just one second. I think if I heard you correctly, you were asking what the economic interest was, and it was a source of income to him?
Yeah, it was several missed reports of $500 or more of income, and I just wanted, and Cadway is the named source, so I just wanted to know what was the form of income. Was it a salary or a commission, or was it some like a dividend on?
I believe it was salary for serving on the Cadway board.
Okay, board director's compensation.
Correct.
And did the city ever use or consider using Cadway services?
Cadway does provide water in a very complicated system to the city of, I believe this is Brea, and they have infrastructure for water in the city.
From what I could glean on the internet, Cadway is a wholly owned subsidiary of California Domestic Water Company.
That's true.
And Cadway is a profit-making subsidiary. And so what I wanted to know, Cadway is apparently managing real estate assets of California domestic water company. So there's possibilities that there could be variances or, requests for concessions on the part of the city on a piece of property. I just wouldn't even begin to know all the various ways that a development company could interface with the city. And so I was trying to get a sense of whether Cadway has been involved in any of the processes in that city.
All we found, this was a lengthy conflict of interest investigation, and what we found after extensive record searches was just this involvement.
Was just what?
Just the involvement in the water rights and the water selling and buying.
But no conflict of interest violation, obviously, because we ended up here with the streamline for the failure
Correct.
report.
Correct.
Okay. Thank you.
Any other questions on consent items? Commissioner Hatch?
That's it.
Okay. Other commissioners, any questions on the remaining consent items? Okay, any public comment for the remaining consent items? Okay, seeing or hearing none, is there a motion?
I'll move approval of the consent calendar except 14, 19, 20, and 21.
Second.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Rumkey.
Yes.
This motion passes.
Okay, so we'll take up the items removed one at a time, starting with item 14. Would the commissioner like to start? I think both Commissioners Odero and Hatch asked for it to be pulled.
Sure. Well, first of all, is Ms. Bertani even, is she here? No. Okay. So I just have general questions, and then I have very specific questions. But I want to start with, if you could kind of clarify the whole procedural posture of where we find ourselves. It was very helpful when you explained it to two of us commissioners, but I think it would be helpful to have a very clear record of where we are, how we got here.
Certainly. Galena West, Chief of Enforcement. So this came in as a complaint, and it came in right before, I think it was March 2014, in January, and then we opened the case, and we contacted Ms. Bartani's committee and said, there's been a complaint filed, there's a lot of reporting errors alleged, and we're gonna have to look into this. And so at that point, she hired a treasurer who cleaned up all of the statements, and we worked with them for a while and came to no settlement agreement. So a probable cause report was issued. Ms. Bertani requested discovery. We provided discovery, which supports all the allegations and any mitigation or exculpatory evidence we had. And then she declined to request or schedule a probable cause conference. So then an ex parte application was put in and approved, and an accusation was issued as a result of that. And she also didn't request a hearing, so then a default was prepared and sent to
File
her.
a defense, correct?
File a notice of defense, correct.
Not.
She did not. And so then a default was prepared and served upon her, and we sent her other correspondence and contacted her. And so then she filed a response to the default, asking for a zero fine as opposed to the $18,500.
But her response is entitled request for reconsideration. And so that, just to make sure the record is clear, that's technically not the proper.
Correct.
But we're
Correct.
taking it as, we're trying to help her out. And
We're trying to help her out. So it was supposed to be a comment or a objection to entering a default, and she entitled it a request for reconsideration. which after a default has been entered, they do have, under the regulation, the respondents have a right to ask for reconsideration from the commission at the next hearing. And then after that, once a final judgment has been entered, 30 days to file a writ.
So today, we have the default before us,
Correct.
not the reconsideration.
Stage one of the three.
Okay. Okay. Thank you for that. That's very helpful. This was an interesting case because this is the first time that we actually got to see some things that we're not generally privy to. And we had the benefit of looking at a negotiation strategy, right, which is an unusual position for us. Very enlightening, I would say. But I do have some questions about that. And I will say that the first thing that jumped out at me as I was reading some of the communications that went back and forth is that one of the things that was said by staff, by enforcement, was, you know, we're offering you this, but you know, those commissioners, you know how they are. In the past 3 to 4 meetings, they've increased the fines. So I remember those past 3 to 4 meetings. But just for fun, I went and I actually listened to them again. And it is blatantly wrong. We did not do that. So 14 things in those meetings were pulled out of the calendar, out of the consent calendar. And there was discussion about a lot of them. But out of all of those, we only increased the fine once. And I find that a troubling negotiation strategy. I question the ethics. I think that's not something that we as a commission want to be part of. And so I guess maybe I'm missing something. So what am I missing?
Besides that attorney doesn't work here anymore?
Well, I think we're laughing, but that's a big statement in itself.
It is a big statement on it in and of itself,
Which of course you can't make because of privacy issues.
just that she doesn't work here anymore.
Okay.
That's all. And I agree with you. I think the tone at the time was to asking for increased penalties. I don't agree that that's a negotiating tool. I think after reading the communications, she was trying to express why she would not go lower as opposed to trying to bump up the fines. And I think that is just a rationale of saying, okay, we could go through all these motions, but from the tone of what's happened, I doubt that they would approve this. And so as an opinion, I think that it was okay, but as a negotiating tool, I see the concern.
Yeah, and I appreciate that, and maybe it has to do with training. I think you mentioned earlier that, not here, but earlier, that she was a new attorney, and so, maybe some guidance would be helpful. Enough said on that issue. I do have another question, which is, in that same communication, the fine for, I think it was the 24-hour report, was $2,000. And then it ended up at $2,500. So what happened there?
Everything that's in the communications that were attached were not charges that went forward. So none of those are included in the papers before you. They all, once we had other evidence and we looked into, and her supervisor as well as me, then when we look at the case, then we say, this is too close to call. It didn't get notice or whatever. So just to clarify that none of those are in the default before you.
Right, I had trouble matching
And we
up
didn't
the
even know
dates.
that. And we didn't even know that at the time when what was going to be in her response. So that was pretty good. So then, but as to the fine amounts, we try to always stay the most current. And as you can tell, this case has gone on a while. So we try to take whatever the commission is currently doing as the most current comparable cases to come up with the fine structures. With default's a little harder because they're fewer and farther between. So that's what would show a differentiation between 2,000 and 2,500.
Okay. And then I do have a question about the comparators that were done, or that were used, I should say, Chiang and Working Americans, and Tyron.
The warning letters that Ms. Bertani provided.
Okay, no, I'll get to the warning letters in a second. Sorry about that. The comparators, give me 1 second, I apologize.
Dollywall and Santiago?
Right. So what I saw was that as I was looking at Santiago, I think it was Santiago, and I'll keep looking through my papers to find what I wanted to talk about, but in those cases, the fine was less. It was $3,000 versus $4,000 for the pre-election statement. And I know that we had one pre-election statement at $3,000, one pre-election statement at $4,000, and then one semi-annual statement at $4,000 is the recommendation. And I think the distinction that you're making between the first one and the second and third, I should say, is that in the second and third, as they corrected it, more problems came to light. Is that? And
Yes.
so we're increasing the fine to account for the undisclosed contributions and expenditures that came to light
Right, because
as they corrected.
I agree with you. The first one is occupation employer missing, but the second two were occupation employer missing, and then the amendment shows another almost $20,000 of activity per statement. And so that was significant in that it was such a large percentage. I think it was like 36 and 30% of the activity that didn't get disclosed until 3 months after the election. So that did get taken into consideration, as those can normally, back in the day, they were charged separately. So you would charge a statement and then occupation employer missing and not returning the contributions, because that's another statute that you have to return them within 60 days, and then making them disgorge those contributions as well. And then a second count would be for the same campaign statement with the missing contributions themselves and expenditures. So for us, for these counts, we combine them to be reasonable in this default, to not make it such a giant amount of money, and to make it a fair and equitable default.
But we still increase it. We still treat it as two things.
Right.
I mean, right? I mean,
It bumps the fine per count a little,
Yeah.
but not nearly as much as if it would be separate.
Fair enough. So I guess that's kind of a philosophical question, is, do we take a problem or a violation as, look, you got three things wrong, or you got one thing wrong, but you violated it no matter what, right? Or do we, your approach is, well, the more you violate this, the higher the fine is going to be. And so I just kind of wonder what the philosophy behind that is, and the reasoning for that.
I think my philosophy always goes back to the lack of disclosure and public harm. So we're always looking to see what, even if it's 1 or 5 violations, if everything was disclosed before the election and the public had the information, that's a completely different scenario than if there's a bunch of information missing to where the information isn't out there. Because it's not just about the public, it's also about a level playing field. So you have to have the information before the election. You have to know how much is being spent. You have to know how much is being raised in order to make it an even election. So for me, it's not about the number per count. It's more about the overall public harm of how much wasn't there.
Okay, so that's why you add.
Right.
So going back to I found my sheet on the comparators.
Okay.
So it seems, in Santiago, what worked against him was he was well aware of the filing obligations, he had a repeated pattern, and he won the election, right? Bertani, I guess we can say, was well aware of the filing obligations, had a repeated pattern, although not as extensive as Santiago's, but lost, right? Somebody shaking their head, she did not lose. Sir?
She won the primary and lost the general.
Okay, so she lost.
Right.
Santiago did eventually file, albeit 2 to 3 years late. Bertani filed 4 months late. Santiago cooperated with enforcement. There's question as to whether Bertani cooperated, right? Although I will say that even though the stipulation says, here's our 14 or 16 times that I can't remember how many, we reached out to her, here are the dates. There's not once a mention of the fact that there were communications going back from the Bertani camp. So, you know, I kind of take the stipulation, sorry, not the stipulation, but the default, as not being completely accurate that there was no cooperation, because it does seem that there was a point of, there was cooperation. There was a tolling agreement in Santiago. I don't know that you needed one, so I wouldn't count that against Ms. Bertani, and no prior history of violations in Santiago, and I think the same thing for Ms. Bertani. I don't know, it wasn't.
That's true.
So it seems to me that Santiago was worse than Bertani, and yet Bertani is getting hit with higher amounts.
I would disagree that, because the Santiago was $4,000 per count, and Bertani is being recommended at $2,500 per count for those same counts.
Oh, you're talking about the late contribution.
Yes.
No, I'm sorry, my bad. I wasn't clear. I'm talking about the semi-annual, the pre-election, the 2 pre-elections. Santiago was hit, and then, yeah, for all the semi-annuals and the 2 pre-elections, Santiago was fined $3,000, but Bertani is being fined $4,000.
Okay. And his was less activity per statement. So that was the big thing. So in the chart in Santiago, it says his semi-annual was $3,200 of activity. His pre-election was about $12,000 to $13,000, and his pre-election was $5,000 to $6,000, and hers was significantly greater. And whether it was filed the 3 years, 2 and 3 years, or the 3 months, it was after the election. So the pertinent election here is the primary. And yes, some of these were filed 2 weeks before the general, but they weren't filed before the primary. She won the primary without the disclosure. She lost the general with the disclosure.
Okay, so she's then she is on a par with Santiago, who won the election.
Right.
Okay, so the only difference I find, and correct me if I'm wrong, because you've been living and breathing this for years, is the difference in how late they filed, and Santiago was worse.
Right.
And yet, Santiago gets $3,000 and she gets $4,000. So can you, and so is your answer to that, well, what the factor that informs this difference is the amount of the activity?
Yes.
And is that consistent with what you've done regularly in the past?
Yes. So when we look for comparable cases, we generally look for cases that have the same level of activity, or we use a case that has a slightly different level of activity, but we give that as a difference. We say this comparable case is similar in other respects. They're still in office, it was this much late, these are these types of statements, it was filed correctly by the other side, whatever those factors are. But sometimes the amounts are different, and we point that out in the comparable, and we say, but this should be $500 or $1,000 lower because it is significantly less, or it should be $500 or $1,000 higher because it's significantly more. So we use the comparable cases only as the baseline, and then try to find the ones that match the best. But you're not going to get them to match completely. So sometimes it's this factor that's different, and sometimes it's another factor that's different. But we just try to point it out and be able to say, this is just one factor of the 5 that are different. This is why it should be given greater weight or lesser weight, and try to be consistent in that.
And when you come to that point where you say, I just don't have the right comparables, how do you decide how much more or less? What's the math there, if there is math? I mean, it sounds like it's kind of more like you're holding up your thumb.
Yeah, it's not an exact science, but it's generally from what the commission has said they find to be the most important. So when I ask you guys questions and I say, is timely disclosure more important, or is it the content of this campaign statement, and get the commission's feelings and opinions on what they find to be the worst public harm and use those as the weighted factors.
And when was the last time that the commission actually sat down to give you these thoughts or directives, as I've called them in the past, which has been objected to? When was the last time that was officially done? Not in the context of these discussions where you're kind of trying to glean rules, right? Mm-hmm. When was the last time we actually sat down and had a discussion about the priorities of enforcement?
It was probably the Streamline Memo adoption in May 2015 when they spoke about how they felt about the different violations and gave opinion and direction at that point.
And the non-streamline, when was the last time we did that? The commission did, I wasn't there.
I think that that's more fluid, and it changes with each commission's makeup. So it's a trial and error presenting, because this is really what we do. We present stipulations, you give us feedback, we direct the cases based on the feedback, because we're just trying to settle the cases as fair and equally as possible, try to stay in the middle as much as we can, and then go up and down based on commission guidance. So I don't know if the commissioners know how they feel in abstract, whereas when they have a factual scenario presented to them, then they say, oh yeah, I agree, this is terrible, or I disagree, I think this is not terrible at all. So I think that is the challenge of it, is talking about, yes, I think contribution limits are important, or I think they're stupid, or I think that this is, it's kind of I could get an overall policy feel, but it wouldn't be specific enough, I don't know, to be helpful.
Yeah, no, I understand. I kind of liken this to, and please don't anybody make a bigger deal out of this than it's just sentencing guidelines, right? Which are guidelines. Mm-hmm. And I don't have a sense that that direction has been given, or at least for a very, very long time, such that you're kind of trying to figure it out rather than us sitting down and just going, hey, here's what we think is most important, here's this, and then going from there. Mm-hmm. And maybe that's something that we need to do. But okay, you've answered the questions that I have on this matter. Thank you very much.
Other questions on item 14 from the commissioners?
Yes.
Commissioner Hatch?
It seemed like there was kind of active discussion back and forth, emails and perhaps even phone calls, right up until the 30th of October 16th. What happened? Why did this sudden stop?
Galena West. I'm going to try to not speak too much out of turn, but I think what happened was Ms. Pertani had hired a treasurer to help her amend her statements when the complaint was filed. And he was very successful, and he's the one that you see the communications with. He was very successful in getting the campaign statements up to date and in compliance, and settlement offer was made and agreed to, and just the money portion never arrived. And so then I believe the treasurer then separated ways with Ms. Bartani. And after that, the communication was much more sporadic, if much at all.
Oh, so that active stuff on the 29th and 30th of October of last year, that was the treasurer was responsible for that?
Correct.
I see. Okay. That would make sense. Seems like there was sort of a wall of silence after that on the part of the Bertani camp. Is that correct?
Correct. Not complete silence, but deafening silence, if there's a difference.
Okay. I'm a little troubled by three of the charges, the counts. There's counts 4, 5, and 6. And I'm a hawk on 24-hour reports. But having said that, these are in-kind contributions from SEIU. And as a candidate, you can't report an in-kind contribution until you know what the value is. I mean, you can't fill up corn property. You can't say, I got an in-kind contribution and I don't know how much it is. You have to have something. And the allegations from the Bertani camp was that they filed those within 24 hours of receiving the information from SEIU, and yet they didn't go away. So my view on why I'm such a hawk on 24-hour reports is when the last report that's made before the campaign, before the election, and the 24-hour reports, are usually the most important that there are of all the reporting that's done around campaign and election committees. And when I see cases where they didn't do these until well after the election, that just makes me breathe fire. But in this case, it looked like there was an honest attempt to comply. Those are still there was no settlement or at least a meeting of the minds between the Bertani camp and staff here in enforcement.
Galena West again. Those 3 counts that you're talking about in Exhibit A15, there are the timely filed letters from Olson, Hagel, and Fishburne providing notice of the in-kind contributions. That was timely, and those reports were not filed. So the difference is in Ms. Bertani's correspondence that she sent us, none of those 24-hour reports are in the documents that you have. None of them have been charged. So the ones that are in controversy are not included in what you're being asked to approve.
Oh, well, they're in the attachment to this item. Let's see.
Right, and after discussion, we didn't include any of those in the charging.
Oh, well, it's not the charging. I'm on like page 9 of the document.
Yes, counts 4, 5, and 6 are all 24-hour reports that they were notified timely by the SEIU, and the evidence is attached that they were notified timely, and they did not file those reports. So those are not in controversy. They don't deny that those weren't filed timely, or at least not that I've ever heard of. The ones in the correspondence that she provided are different contributions.
Now, this response that we received, this written response just before the meeting, and I apologize, I was not able to read the entire thing because of the lateness of the hour. Would seem to make me believe that this is going to head to litigation. Do you disagree?
I believe if this was going to head to litigation, she would have asked for a probable cause conference or an administrative hearing. which she did not do.
Well, tactically, she may be wanting to skip the administrative law judge proceeding and go direct to court.
She could, as I was talking about the procedure earlier, she could ask for reconsideration next month and then file a writ based on the order of the commission.
Okay, thank you. Madam Chair, when it's appropriate, I'd like to make a motion.
Okay, I'm going to wait for further questions first from other commissioners. Commissioner Hayward?
Thank you. This is more of a question that's applicable to, I mean, we've seen a couple of in-kind contribution problems in this packet, and that makes me wonder. So if you don't get timely notice of an in-kind contribution, do you then get a pass on not having to file that you received it until you do? I mean, how does that work?
That's a good question. No, our definition, 18421.1, talks about making and receiving contributions. And in that, it specifically talks about non-monetaries. And it talks about that it's when you get knowledge of receiving it or you get the benefit of it. And then there's another regulation that says you need to make a good faith effort estimate if you don't know. So if they don't tell you, you have to make an estimate within the times that are prescribed for your 24-hour, 48-hour reporting. And then if you're off by 20% or more, you go back and amend later.
And it's not a violation if you do it that way?
Right.
Okay. So because, you know, they're in-kind contributions that are fairly easy to evaluate. If somebody hands you some Canadian maple leaves, you can go online, you can figure out what they're trading at. And not that that would ever happen, but it's kind of an interesting idea. But something like having purchased, lunch for all your volunteers, and something that's not maybe all that easy to identify as the recipient because you don't have a check stub or a receipt, or then very hard to find define values, so the 20% rule was not something I was aware of, and I think makes sense. So you file it when you need to file it, you do your best, and if you're off by 20%, you amend, and then it's a nothing burger, you're fine.
Right, and that's one of the factors that we are mandated to take into consideration, that you've made a good faith effort to disclose, and the regulation gives you that option.
Do you have another question?
I do. Nope, I'm done.
Okay, thank you. Commissioner O'Darrow?
So I have two questions, but one specifically about the 20%. So what if do you have to amend before the election to get the pass?
I don't have the exact reg in front of me. I was going to get it out, but I think it's with when you get knowledge that your estimate was off. So you get the notification from them, then you have to modify it. I don't know the whole reg by heart.
No, fair enough. But what happens if you get it on their information, the donor, the contributor's information, the night before the election? Then do they still get the pass?
I think generally if you're it has to be within 20% for you to even get into this safe harbor. So if you've underestimated grossly in order to avoid disclosure, it's under $1,000, I don't have to file a report. Something like that, then we would take all that consideration.
What is grossly to you? Because is it just anything above 20%? Is it 21% or is it 40%? You know what I mean?
Yeah, I know. And for me, it's hard because in investigation, you usually have a little bit more information and usually have some email correspondence where they say, estimate this at $10 and, we'll fix it after the election and then nobody will know. So for me, there's usually other factors that I can look at. But it would be case by case because you're looking at size of campaign, you're looking at size of the contribution. If it's maple leaves and maple syrup and it's not a too big of a deal, then your 20% could be off because everything was only worth $300. So that's why it's hard. I hesitate because it just becomes minuscule when it's a $1 million media buy, and then you apply 20% and it can be quite a little bit of wiggle room. So 30% is a giant miscalculation.
Yeah.
So,
It's tough. I feel your pain, but I also feel the pain of the other side, where if there seems to be no guidance other than the 20%. And being an attorney who represents employees, not in this circumstance, but of course in terms of agency enforcement, I look for that kind of guidance from agencies, and I think it's fair to provide it. So, I guess maybe we have to come to some kind of terms on what kind of guidance is going to be provided on this, but.
and we do look for good faith, so we're not really, if you're reporting something and it's out there that Commissioner Hayward is your biggest supporter, because we're looking at that. So we're taking everything into consideration.
Yeah, fair enough. Thank you for that. And then my final question, which I started to talk about and then I forgot. Why not a warning letter?
Well, warning letters are reserved for things that are technical, right? Things that are de minimis, things that don't qualify for streamline. So why not streamline? Why not a settlement? You look at the numbers of what she didn't disclose, and you look at the streamline program, and the size of some of these numbers make it even questionable that she would qualify for streamline. So when you look at that, and you look at the amount of the other cases that are here, so you look at the Jobs PAC case, and it's similar non-monetary contributions, and the month before we had the companion case for family farmers, it's the same type of non-disclosure, not before the election, public harm. And when you look at the streamline memo that we'll look at again in detail in January, the factors tell you these are aggravating factors that deserve to be fined.
So compare Chiang for me.
Sure. Okay, so the John Chang warning letter was presented by Ms. Bertani as a warning letter that's comparable to her situation. And what I would say about all three warning letters is that there was disclosure before the election, which is a huge factor. So if you're looking to not be fined, you really should amend your statements and disclose your information before the election, so there's a level playing field and the public has the information. So I would say that is the baseline for these three warning letters on why they are inappropriate. And then, so Chang is also a very old letter, but it's 165 late contributions received, and 2 for $1,000 each were not timely filed, and 16 were late but filed before the election of $31,000 out of almost $400,000 in late contributions. So de minimis in the amount in comparison to the large amount of the Bertani late contributions that weren't filed.
So 10% to you is de minimis?
10%?
Well, so almost 10%.
Well, the $31,000 was filed before the election.
Oh, I see, okay.
So we're only talking about $2,000. Okay. And then for the subvendor information wasn't included in the Streamline program until May of 2015. So the 84211 violations for disclosure on campaign statements it was very discriminating as to what you can even get Streamline for. So your choices back then, which is why I pointed out how old this is a 2006 committee, and your choices back then for the semi-annual ending in 2006 was, first of all, we no longer include postage as one of the subvendor requirements that we will enforce against, because everybody knows that if you mail something, you have to pay postage, and if you didn't put U.S. Post Office, the harm is minimal. So it's not usually considered in the amounts. And then also, whether or not these was one media buy, I'm not really sure, because it's based on an FTB audit I no longer have access to. But so the amount out of $3.4 million for $500,000 in subvendor back then wouldn't have warranted the $3,500 fine that it was the option between that and a warning letter. So a very different circumstance.
So not apples and apples.
Right.
Okay, and then what about Working for Working Americans? Because there, they failed to disclose 2 contributions of 5,000 each, or more, 5,000 or more each.
Sure, and they failed to disclose it on the correct forms. So all of their disclosure also happened before the election. Their problem was they filed as a major donor committee when they should have filed as a recipient committee. So they filed reports, they just didn't file appropriate reports for becoming a recipient committee.
But didn't Bertani do the same thing? Wasn't part of the, correct me if I'm wrong, but wasn't part of the mitigating factors for her that the amounts were reported in other forms?
The SEIU LCRs. So 2 of them were reported before the election and 1 was not. So the $7,000-something one was not reported before the relevant election.
So Working for Working Americans didn't disclose 2 at 5,000 or more.
But all the disclosure happened before the election in that case.
Okay.
Which is what all these warning letters have in common.
Okay, got it.
And then for Tyrone Hampton, I mean, he actually filed before we even contacted him, amended everything before the election. So it's like, thank you, Mr. Hampton, I think is what the letter says.
I'm done. Yeah, I'm done.
Okay, thank you. I would just like an opportunity to speak for a second, because I feel, from my point of view, and I've said this before, that we're giving this respondent way too much lenience, opportunity. Technically, she's in default. She's a sitting official, an attorney, and the notion that she's cooperated, I find difficult to accept. I mean, she did not respond to or participate in the probable cause opportunity. She did not file a defense. From what I understand, you said she entered into an agreement, a stipulation, and then did not comply with it or follow through. And that's why we're still here talking about this case much longer than we should be as far as time since the events occurred. I find that troubling. I find it troubling that she hasn't done anything, but yet we still view her response at this stage. Again, if she wanted to make her argument, if she wanted to consider a lower fine, she could have done so at a hearing or even showing up at the probable cause hearing. I mean, to me, as I've said again before, I think when we reach default and we talk about clear violations, and I consider these serious violations, I think if anything, the proposal's too low on all of the violations. Again, I think default is you really look to the 5,000 and try to tell me why we're not hitting people with 5,000. Again, we're encouraging people not to participate in these proceedings and come forward and reach a resolution or exercise their rights and go to a hearing when we sit here at a default hearing and consider all their best case scenarios, which I do not think is appropriate. So that's just my 2 cents on defaults. Commissioner Hayward?
And I guess I came here needing a lot more education to even know how I felt about this default. I think part of the issue with why we have these questions is that we don't have these documents before us for very long before we're supposed to make a decision on them. And I'll just say I don't have a problem with finding her in default. I don't have a problem with the default report as it currently stands, but I really did feel like I got a lot out of the colloquy this morning. So
no, I'm sorry. I didn't mean to say that we shouldn't discuss it. I'm just saying my point of view about defaults in general.
Yeah.
I think once the evidence is there in the motion, sure, let's discuss should it be higher or lower. Is it the adequate amount? Totally agree. I'm saying I have concerns when we start making her case for her to some extent and taking into consideration what she states in her response, including that she should get credit in mitigation for cooperating. I guess that was my response to that. She asked for it, and I do not see how you get credit for cooperating when you have a default motion going.
Okay.
So I'm sorry to, that wasn't talking about this discussion.
I'm not pointing at you as much as just sort of pointing at the audience and the people viewing from home that we have taken a long time on this, and I tend to look at the defaults kind of closely just for things like odd due process things like notice. You know, our jurisdiction reaches to, you know, the very smallest of public offices and with a lot of people who aren't sophisticated. And sometimes a default is a mistake, and sometimes a default is much more willing. I think this one is much more willing. And so like I say, I don't have a problem with the report. I think she's culpable, and let's see where it goes. That's all I have to say.
Commissioner Hatch, you had another question?
Actually, I was just ready to make a motion, but I'll wait until the appropriate time.
I'm sorry, I didn't understand that. Can you repeat that, please?
Oh, I'm sorry. I did, but I think it's, I had another question, but I think it's not necessary to answer it, so I'll just wait until the appropriate time to make a motion.
Okay, any other questions from the commissioners, or I'll ask for any public comment on this matter?
I just have a comment.
Okay.
So just further to Commissioner Hayward's statement, I wholeheartedly agree that we should be discussing these. I understand a default. I know what it is. I've been lawyering for quite some time, so I know what it is. That said, I think that our situation, not in this particular case, but in some cases, could require some additional attention to be given to the smaller, unsophisticated player, if you will, much like a court would give a little bit of an edge to, or assistance, I shouldn't say an edge, assistance to a pro se filer. And so I would not want to have the discussion about mitigating circumstances or how we got to the default silenced merely because, well, here we are. So that's just my 2 cents on that. I guess it's not really a question, it's just a statement.
Okay, if there are no more questions from the commissioners, is there any public comment on item 14? Okay, seeing none, is there a motion?
Yes, Madam Chair.
Commissioner Hatch?
Yes. I move to postpone consideration of the default judgment and send the matter back, instructing Enforcement Division staff and the respondent to try and reach a last-minute settlement. That's option 3 in the memo sent by Chief Counsel.
Okay, I just have a point of information on that motion. I just want to make sure I understand the record. So you said you already did enter into a settlement with her, which she signed, is that correct?
Yes, Galena West, we had a signed settlement without the full payment.
And then she failed to comply with that signed settlement?
Quite a while ago, yes.
Okay, I just want to make sure that that point of information is clear. Okay, so there's a motion to not take action.
Point of information.
Yeah.
Further to that, if you would just give me 2 seconds on this. Why do we have any, not speculative, do we have any information as to why she failed to comply?
She would like to not pay.
Okay. Got it. Thank you.
Okay, so there's...
So her non-compliance was that she didn't write the check to go with the STIP.
That is correct.
Thank you. Okay.
I have a motion. I don't have a second.
No, I'm just wanted, so I think we all got our questions out on your motion. So there's a motion to not take action on this and direct enforcement to try to reach a settlement. Is that the motion?
No, the motion is to postpone consideration and send it back to enforcement to try and, for enforcement to try and work with the respondents to try and reach a last-minute settlement. Unsaid in the motion was a presumption that it'll come back before us for the recommendation.
Is there a second?
I'll second it.
On my motion, if you would, Madam Chair.
Sorry, what did you,
Yes, if I'd like to speak on my motion, if I could.
well, there's been a motion and a
Yeah,
second. There has been a second.
Yes.
So we'll
I
have,
heard Commissioner Adaro second it.
there was a
I did.
second.
I did.
Okay, so we'll take roll?
Commissioner
I
Adair?
asked to speak on my
Oh,
motion.
okay, sorry, I thought you were waiting to see if there was a second. I'm just trying to follow along here. So go ahead, Commissioner Hatch.
Yeah, on my motion, it seems that for whatever reason, there was a lot of back and forth up until a point that somebody did something, then something, I don't know what, but this looks like it's gonna head to litigation if we can't figure out a way to settle it. That's why I'm making this motion. It's one of the three recommended by Chief Counsel.
Can I?
Thank you.
I guess I'm confused by the concern regarding litigation, because if we look at this procedurally again, which is kind of the emphasis I'm making on the default process, once we enter a judgment, the issue for any reconsideration and ultimately the court is, should that default be set aside? Are there grounds to set aside the default? It's a default judgment. And I would find that hard to find any court who's going to agree that a default should be set aside in this, but that's my position. So, okay, is there any more?
The further that we allow this to go, the less options we have as a commission to resolve this.
Okay, any more
Less
discussion?
flexibility.
Any further discussion on the motion? Okay, we'll take roll.
Commissioner Adaro?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
No.
Chair Remke?
No.
Motion is tied.
Okay, is there, well, I'll move to approve the default order, decision in order.
Second.
Commissioner Adaro?
No.
Commissioner Hatch?
No.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
The motion is tied.
Okay, so we'll take no action on this. So if someone could help me out procedurally. No, I know that. I'm just talking about item 14. So there's no action, so it doesn't preclude you from pursuing the matter. Okay. Okay, item 19.
That was one of mine. I noticed the default decision again over an item. This is as I recall, what do you call it? The Form 700. Not filed timely. And if this had gone to Streamline, it would be about a $400 issue, but the proposed fine is $8,000, which is 20 times that amount. I realize it's because of lack of follow-up on the part of the person charged, but seems like that's a bit out of the line. Galena, could you enlighten me as to why this is appropriate nonetheless?
Certainly, Galena West. What has traditionally happened in defaults for SEI is that if you are holding an office, say in this case is a planning commission, and you do not file your SEIs, if you comply, file your SEIs, and you can get a streamline, which is, as you said, a couple $100. And if you refuse to file them, if you just will not file your statements of economic interest to show what your economic interests are while you are in office, then you cannot get a settlement. So the public harm increases significantly when someone is on, say, a planning commission and they won't disclose what their interests are. So Mr. Grewal was actually removed from the planning commission, but traditionally the commission has always found that if you are not cooperating, you won't file the SEIs and you won't disclose your interests to the public or to even the agency you work for, then it has been a much larger fine. It used to be all max fine. It used to be all $5,000 for any default of not filing your SEIs. And then the considerations for being out of office or having filed subsequently once you were out of office have been taken into consideration as well as sometimes leaving office versus annual. So I would say those were the considerations that caused the commission to actually lower the fine from $5,000 to what you see now. But generally, this has been considered a make or break issue for the commission that the statements of economic interest while you are in office must be filed.
Did he ever file them?
This case, I do not believe so. Never filed.
Okay. Then I move approval.
Any further questions from the other commissioners? Any public comment on item 19? Okay, hearing none. Your motion, Commissioner Hatch?
I move approval.
Second.
Commissioner Darrow,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
Motion passes.
Item 20.
This is similar, at least as how I read this. This is, if it were streamlined, it'd be about a $400 fine, and this is $7,000. Did he ever file his forms?
Well, he filed yesterday.
Okay, so he gets $1,000 off.
There you go. It's amazing what a default on the agenda can do.
Yeah.
So that's 2.5 years late.
So close.
Any other questions from you, Commissioner Hatch?
I move approval.
Yeah, okay, sorry. I'm just trying to make sure we get everyone an opportunity before we
Yeah,
make
no,
a
I
motion.
understand. Sorry.
Any other questions from the commissioners? Any public comment? Okay, so you move approval. Motion to approve has been made.
Second.
Commissioner Darrow,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes,
This motion passes.
okay, and item 21.
Item 21 is another form file. This is was labeled as a streamlined, what do you call it, stipulation. And I lost my place here. Okay. Looking at the grid on this, it shows that he was proposed fine of $600 per violation, whereas the next, items 22 through 34 are all $200 per violation. They're both streamlined. They're all streamlined, and they're all for the same thing. So I asked Alina, why 600 in this particular case, but where they're all, the rest of them are 200.
Sure, that's a good question. And our streamline memo that we follow for compliance in response to the first enforcement contact is $200. But compliance prior to the issuance of a probable cause report is $400, and compliance prior to the issuance of an accusation is between $600 and $800. So in this case, as you can see, this goes back to the 2011 annual SEI that wasn't filed. So this case has gone on for a while to get Mr. Klompus to comply. So as it goes through the process, the fine is increased.
Okay, so he had had those other two things served on him. I'm sorry, I didn't catch what they were.
The probable cause report and finding a probable cause.
Okay. Madam Chair, because I'm hold up on this, I would move to approve.
No, any other questions? Okay, no public comment? Seeing none, okay, motion? Is there a second?
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
Motion passes.
Okay, I'm just wondering if we can give Ms. West some further direction. I'm kind of just sitting here thinking how we've left item 14 hanging with no action. And I guess by default, she'll go back and try to reach a settlement as was requested. I would say from my personal point of view, and I'll leave it up to Ms. West, if she can't reach a settlement, I mean, her only other cause would be to seek litigation, which I would not avoid. I mean, to me, the worst-case scenario is that someone doesn't show up, we can't agree for various reasons on the course of action, but she ends up getting no action. I think that would not what our intent was if I understood the discussion.
Madam Chair? Yeah, I don't think anyone means to give her a hall pass. I think it's just the way forward that we disagreed about, but moving forward is something I think, I shouldn't speak for my colleagues, I think, but my sense was that's what we wanted.
Okay. Any other comments on that or direction? To move forward, see what we can do, and then we'll bring it back in one form or another.
So let me just state my thoughts.
Okay, Commissioner Odero?
I agree, this is not a pass. That in my mind, this is not. I think we're disagreeing perhaps on amounts. And so, I think the best option is see if you can go get this settled or come back to us with a default that we can agree on.
Okay.
Commissioner Hatch, did you have a comment?
Yes, I did. Thank you. I just want to confirm again, Galena, that items 4, 5, and 6 that are on our memo are not a part of this default charge.
Counts 4, 5, and 6 are different than the ones that were contested. So yes, they are included, but the counts that they were discussing, that the treasurer was going back with the enforcement council about, were different counts, different dates, different amounts. There was, I believe, $90,000 in non-monetary contributions, and those were for different non-monetary contributions. So the ones that are in here were not filed.
4, 5, and 6 are non-monetary contributions where they received the information from the contributor late, but they were within 24 hours of the date they received that information. Is that not correct?
They received the information timely, as in Exhibit A15, the letters from the contributor. So there's no contention on whether or not there were 24-hour reports due for those contributions, that they received the information timely from the contributors.
Okay, but our law, and this is not you, this is what we've done in the past, requires that the receiver file that 24-hour report within 24 hours of the contribution. And whether it's a media buy or a mailer, it's very difficult for the receiver to know what they've received until they actually get something tangible. I mean, you get rumors at first. Oh, I saw something on television. Well, how big is the buy? I don't know. Oh, I got something in my mailbox. Well, what was the universe? Was it just 4 out of 5 frequent voters, or was it all Democrats or all Republicans? There's no way of knowing that until you get information, and it comes in, in trickles. But our law requires that they do it literally before they receive the notice from the contributor. And I recall reading it the other night. This easily fit that category. where had they gotten the information when the contribution was made, they would have been able to file timely, but because of the two-step process, they're in violation of our law. And to the extent that's true, you want input, I don't think we should charge those three. And I think we should revisit that rate.
Well, I think Ms. West is, and this is Chair Remke, again, there's the confusion because the attachments by the respondent talk about that situation where they may or may not have received timely notice. The 3 counts that are charged are best summarized on page 7 of the decision and order, the first full paragraph where it states the date of the in-kind contribution and the timely notice from the contributor, which all was within 1 day, 2 days, 4 days. But yet, despite that timely notice, they filed no 24-hour reports.
That's correct.
Okay.
And we included those
No
timely.
24-hour reports at all?
No, not at all for those 3 contributions.
Okay, I'm sorry, I was confusing that with the ones where they filed it
Right.
within 24 hours of receipt of the information, but not within 24 hours of the actual gift.
Right, so they didn't disclose anything. The mitigation we used was that 2 of them were on report, other statements, but no 24-hour.
They were on the donor statements, correct?
Right. So no 24-hour reports by Ms. Bertani's committee for those 3 contributions.
Okay. Thank you. Appreciate that.
Mahalo.
Commissioner O'Darrow?
So, Ms. West, do you think that you can cut a deal with Ms. Bertani? I mean, not for $1. That's
Right.
off the table, right? I mean, I think I won't speak for others, but for me, that's off the table. I wouldn't vote for that. But some kind of reasonable deal that, that will just get this done. At much less expense to us as a commission, because going forward is going to cost a whole lot more than $18,000, right? I think we all agree on that. And I think we have to be reasonable with our resources. So, I mean, that's kind of where I'm going. If you can cut a decent deal, I think that you come back with another default. Or either you cut a deal or you come back with a default that we'll approve.
Okay.
Yeah. I would just say the counter to the concern about cost to us is there's no cost for a default. We get a judgment. So if we can't reach a deal, I mean, I just don't want us to say we want a stipulation at all costs. And I know that's not what you're saying.
Yeah, that's not what I'm saying at all.
Yeah. Okay. All right. So that is to be revisited. I think we've all given our thoughts and directions on that. I just didn't want to leave that hanging. So thank you, Ms. West. And now we move to item 36, adoption of amendment to Reg 18531.5, campaign manuals and fact sheets. If you could just state your name for everyone.
Okay, I think that's working. All right. So, good morning, Chair Remke and Commissioners. I'm Zachary Norton, Senior Counsel, Legal Division, here with Trish Mayer, Assistant Chief, Legal Division. So, today, staff is proposing amendments to Regulation 18531.5, as well as to the Recall Fact Sheet and Campaign Manual 4. And I'd like to note that there was a proposed change to the recall fact sheet, the addition of question and answer number 19, and that was in response to a concern raised by Commissioner Hatch. At its October meeting, the Commission, consistent with the Rios opinion, adopted amendments to Regulation 18535 to make clear that the contribution limits of Section 85305 do not apply to state candidates who are the subject of a recall. The regulatory amendment proposed today is the result of a public comment following the adoption of the Rios opinion. Staff is also proposing changes to the recall fact sheet and campaign manual to reflect the change resulting from the Rios opinion, as well as unrelated changes. Those would include a minor clarification reflecting the advice in the Piercy letter and updated references to the Commission's current Q Street address.
Thank you. Any, so can you just again to clarify for the record, so I understand that there are copies outside in the hallway for anyone in the public, and I just received the changes. I guess there was suggested changes to the fact sheet. Is that right? Where are the suggested changes, just so I know what we're talking about? Okay. Okay, so it's question 19?
Yes, question 19 originally had been stricken in its entirety, and then as a result of comment from Commissioner Hatch, we've reintroduced it with modifications.
Okay. This is just, okay, so 19's back in with amendments. All right, thank you, Zach. Any questions or comments from the commissioners first?
I think it's a point of order.
Okay, Commissioner Hayward?
Are we going to take the reg, the fact sheet, and the manual separately, or are we going to consider them as a unit?
I think I would propose we take them separately.
Thank you.
So with that, any questions or comments regarding the regulation first? Let's take the regulation first. That seems to be the most straightforward. Okay. Any, well, I'll take the public all at the end too. Any questions or comments from the commissioners on the recall fact sheet, considering the proposed recent amendments as well from Commissioner Hatch?
I would just say that I think the Hatch version is just fine, though I have to say I'm not sure I had problems with the pre-Hatch version. I'm not sure we have to specify that the replacement candidate, being a candidate for office, does not enjoy the lack of a limit. But you know, if to the extent there might be confusion on that point, then sure, let's make sure it's specific there. Thanks.
Okay, thank you. Commissioner O'Darrow?
Thank you. So I was not a fan of cutting out question 19, or I think it was question 18 in this. Yeah. I don't know. The one that we got is weirdly numbered.
Yeah.
It doesn't have a number on that question. Notwithstanding, I'm not a fan of completely eliminating this question because people have been looking at this question for years now, right? And to completely take it out, I think, is going to lead to confusion and perhaps more calls than you would want to take. So I'm not a fan of taking it out. So I like bringing it back in as what is now numbered question 19 on this Hatch version. But I also would like, my instinct was initially was, why don't we just tell the people what happened? Why don't we just say, you know, our contributions made to other elected officials to the blah, 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 the question number 19, and then just say no on this and yes on this. I mean, why are we kind of beating around the bush and hiding an answer is what I feel like. I feel like just tell people.
Zachary Norton, I think that's what we're trying to do with the recall fact sheet. I think it's trying to sort of spell it out in a way that presents questions and answers that Trish and the advice staff have dealt with in the past. So it's attempting to be kind of a usable document that presents things in kind of a real world sort of common language manner.
So What's wrong with saying, "Are contributions made by other elected officials to the target candidate subject to limits"? No. Are contributions made by other elected officials to a replacement candidate's controlled committee subject to limits? Yes. Just a thought.
There wouldn't necessarily be anything wrong with that, so.
But so is the proposal, or your question is why we add the references after that?
No. My question is, why aren't we answering the question that everybody has been asking, which is, are contributions made by other elected officials to the target candidate subject to limits? To the target candidate, I guess, if I recall. Subject to limits? No.
That's question 2, right? I guess I'm
No, well,
having,
okay.
I'm
Okay,
having a
my-
hard time following.
No, I'm not sure that's question 2. Question 2 is whether that person can receive. I think question 19 is whether another elected official can make, which was 90% of the debate that we had for 3 months, as I read it. I could be wrong, so correct me if I'm wrong.
Commissioner Hayward?
Yes, Madam Chair, I think maybe what they're grappling with is trying to get rid of the make or receive distinction that the commission was following, similar to the regulatory language where we add made to or into it, because we're no longer trying to perpetuate that distinction. If you've got, a suggestion for how to be, clear with people now that we no longer recognize that distinction, I don't know. I didn't have a problem with the Hatch draft on that point. But if Commissioner Odero has a thought, I'd be willing to think about it.
Yeah, so I did have a thought. Okay. So my
Excellent.
is break it up into 2, right? Our contribution.
Interject. I'm sorry.
Go ahead, Commissioner Odero.
You're all right?
Oh. Pardon me? Commissioner Odero has the floor. Go ahead, Commissioner Odero.
Break it up into 2 to make sure we are absolutely clear. Are contributions made by other elected officials to the target candidate subject to limits? No. Are contributions made by other elected officials to a replacement candidate's controlled committee subject to limits? Yes. And the language that is stated here currently. That's I think would make it clearer. I will say that my only goal here is to be as clear as possible and to avoid a whole bunch of calls to your office. But maybe there's a compromise that we can make, which is we leave it as the Commissioner Hatch version, and if we start to get a whole bunch of calls, then we revise it again. I'm fine with that. I just want to make sure that we're as clear as possible so that to save resources and avoid headaches for everybody all around.
So if you're fine with leaving it, and these are the people who answer the questions, and you think you've hit the right tone based on the questions you receive, maybe we start with there, and if they get problems, we'll bring it back it's most likely we will be bringing it back if we adopt further regulations in December. So we could perhaps take that comment under consideration, and if further amendments are made to this, you may work that out a little bit more.
Yeah, although I would say I don't think that by December we'll have enough calls. I mean, I don't think 1 month is a fair enough test of this. That said, yes, I am fine. Well, if you guys feel comfortable, and I guess Ms. West, if you feel comfortable because you're going to be enforcing this, and you don't feel that this is, or you feel that this is clear enough, then let's go for it and see what happens.
Commissioner Hatch? Yes, Commissioner Hatch.
Just to clarify, my first impression was exactly what Sodero's was. My notes to myself were to, write to staff that this should first of all be back in, and that it should say yes for the target and no for the challenger. And the language that you see was actually drafted by staff in response to my concerns. I would be ever much happy with the version that Commissioner Adaro suggested. That adds back in a sentence that makes it clear that the target, that the contributors to a target are not limited.
And this just goes back to my question. I guess I'm still slightly confused. Why question, and maybe I'll ask staff this to help me understand what we're doing, why this concern isn't answered by question 2?
I can answer that. Question 2 talks only to
I'm actually asking staff to just address my concern right now. Thank you.
Hi, Trish Mayer. It seems like question 2 does answer the question.
And I say that because then the issue is, would it be easier to amend question 2 to be more direct if that's the concern? As in, it reads, our contributions made, oh, I see. It could say, is the elected official is the target of recall subject to contribution limits and voluntary expenditure limits, including from other elected officials? And the answer is no.
That would work as well.
Would that be an accurate statement? Just because I'm doing this on the fly, I want to make sure that would be accurate.
Yes, it would.
So if we were to amend question 2, which is up front more, and it's on the recall and the target, which seems to make a good spot for it, who is the target of a recall of a state recall subject to contribution limits and the voluntary expenditure limit, including contributions from other elected officials?
Yeah.
The answer is no. Okay? That would be my proposed modification to this modified version.
Madam Chair?
Yes.
Is that a friendly amendment to the amendment of our friend in Hawaii,
Yes.
Mr. Hatch?
Yes. I'm working off that version. I'm working
very
off.
pleased with it.
Okay.
Excellent.
And to clarify, so we'll leave Commissioner Hatch's version
Yes.
in the other question. Okay.
Yes.
Okay.
That's the proposal right now. So we're working off the amended version that's been available today, making a slight additional amendment. Obviously, no substantive changes, because all we're trying to do is clarify what the law is and make sure everyone understands it. So, including other elected officials. With that, are we done with the fact sheet? Any public comment on the fact sheet? Okay, seeing none, the last, just Commissioner Odaro?
One tiny little change, I would say including from other elected officials, not including other elected officials.
Yes, good idea. Okay, then let's just, is there any questions or comments regarding the manual language? From the commissioners, any questions regarding the manual? Any public comment regarding the manual? Okay, so if we want to take these one at a time, I move to approve the regulation.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
Motion passes.
Okay, as to the recall fact sheet as amended today, is there a motion?
I move approval of the further revised Hatch revision.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
Motion passes.
Okay, and finally, as to the amendments to Campaign Manual 4, is there a motion?
I'll move it.
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
The motion passes.
All right. Thanks, Zach and Trish. Okay, item 37, adoption of the 2017-2018 Statement of Economic Interest. We did receive one public comment, which isn't as to these amendments, but a bigger policy issue as to Form 700s, which is posted online, and I believe the commissioners received it. Okay, go ahead, please introduce yourself.
Good morning, Chair Rumke and Commissioners. My name is Courtney Miller, and I'm the manager in the External Affairs and Education Division. I'm here today to ask for your approval of the 2017-2018 Form 700 and related documents. As I noted in my memo, there are only the updates pertain only to the dates and deadlines in the documents. Staff recommends approval of the updated Form 700, Form 700 reference pamphlet, Form 700A, and Form 700U. I'm happy to answer any questions you may have. Thank you.
Thank you. Any questions from the commissioners as to item 37? I'm sorry, what did you say, Commissioner Hatch?
I said yes.
Okay, go ahead.
Was there any thought given to providing further examples, or is that something that would be done in a different context?
Further examples on the instruction sheet, is that the issue?
Yes.
Do we have other further information or secondary sources regarding the Form 700s?
We don't.
The reason why I raised that question is that, I filled out my first Form 700 in March, the one you do before you take off, or as you take office. And I found in many areas I just really had to struggle, and thankfully there was some kind staff to help me find my way through it. But, I've not forgotten that those information sheets were not terribly helpful. And I think there could be further work done on that in several areas.
Commissioner Hatch, this is Erin Peth. Just this current version that we're asking for approval for doesn't have any additional FAQs, but in the past that has been changed. If we monitor carefully all the advice that we receive, all the advice requests we receive, and if we notice the same types of questions coming up over and over, we do try to keep these documents, as current as possible to be consistent with the advice questions we're getting. But that doesn't mean we couldn't add additional examples in the future as well. And we do, as you know, and I just referenced, provide advice via phone and email and formal legal advice. So if questions are not answered in the documents themselves, we're available to help individuals fill out their forms as well.
Right. I found in some cases some of those facts were contributed to the confusion. So my 2 cents, I think that there's room for improvement.
I know that in addition to everything that Erin just mentioned, we also do provide formal training for filing officers who then really are the first front line to the people filing with them. I mean, there's a lot out there, but to the extent, Commissioner Hatch, you think there's anything in particular in this form that you want to talk with Courtney about, we could revisit that and or just have additional information. We have a page on our website regarding Form 700s, and if there are any things you think would be helpful, I'm sure she'd be open to hearing those.
Okay. I'll try and go back through and make a list, and perhaps if that's all right, contact Courtney with that.
Can you speak a little bit more into the phone? I'm having trouble hearing you.
I apologize. I tend to trail off. That's my suggestion. I will, after my vacation, I'll look through and see if I can find some of those things and contact Courtney. That's all right.
Okay. I'll actually have Courtney reach out to you just so you guys have contact. Okay.
Can I just have a comment on that?
Yes, Commissioner O'Darrow?
So I echo the concerns about the difficulty That said, the first time after my eyes rolled into the back of my head and then rolled back out, I just handed it over. I'm fortunate. I have an accountant that I can just hand it over to, wash my hands of it, and, you know. The second time, as I was going through it, I actually thought, okay, why can't I do this? I'm a normally intelligent person, not the most intelligent, but you know, I'm okay. And I thought, what would I rewrite in this? And so I actually went to the rules and I went to the regulations, and I concluded that I could not write this any better because it's just a nightmare. I think it's the problem in understanding it is not a fault of our or the Commission's efforts to make it clearer. It's just that it's impossible to make it clearer is the conclusion that I have reached. So I'm good with it as it is, and if Commissioner Hatch can come up with some helpful things to add, then not only should we add it, but Commissioner Hatch should go get a job writing manuals. So that's my 1 cent's worth.
Okay, if there are no other comments or questions from the commissioners, is there any public comment on item 37? Seeing none, is there a motion?
I'll move them.
Okay.
Second.
Commissioner Adero?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
This motion passes.
Thank you, Courtney. Okay, so the next item was at the request of Commissioner Odero to come back with a more formalized written statement as to the work that's being done as far as implementation of the Disclose Act and a timeline. That's item 38. So do the commissioners have any questions regarding this document?
I do.
Commissioner Odero?
Thank you. So first, thank you. This is exactly what I was looking for. I think it's very helpful. But I didn't go back and read every single one of these regulations. So I guess I would ask, what was your reasoning for the order in which things are done? I had raised a particular question about earmarked funds, and people are going to have to start tracking that, and I want to make sure that we're on track with that, and then I'd love to hear your reasonings.
Sure. I'm actually going to defer to Suki from the legal division. She's handling all the regulation packages.
Hi, Suki Brar, Senior Counsel, Legal Division. So our reasoning for it basically is there are a lot of regulations on the list. There's about 18 regulations. So we started off with the ones that we found to be more of the simple ones to get them out there as fast as possible because we could get those out more quickly. And then we're going with the second set for the January regulations. We find those to be a little bit more complicated, but the plan is the bill doesn't go into effect until January 1st, and we're going to put all of the regulations together and have them go in effect at the same time. That's for ease of enforcement as well, so we don't have two sets of regulations out there that are implemented at different times also. So that was the thinking behind this, and we're having a interested persons meeting on the first set of regulations on November 28th, and then another one for the second set in the middle of December.
Thank you. So, okay, I appreciate getting as many out as possible, but was there any thought given to the fact that some people are going to have to start doing things right away? On earmarking, for example, where's earmarking?
Right, so there was thought given to that, and again, we're making all of the regulations go in at the same time. Enforcement will give a grace period for that as well, and the bill itself has a lot of information in it already when it comes to earmarking and how to comply with that. So I think we're okay on that front, and again, we need to have a lot of public comment on that as well. So we're trying to get that done as soon as possible and have the meetings where people can give input as well.
So where's earmarking?
Earmarking
is in January.
Yes, that will be up in January.
Well, no, nothing is going to be out in January, right? Because the December meeting is going to address this first set, and then the January meeting is going to address the second set, and nothing is going out until after that. right?
So the second set includes the regulation that might address earmarking.
Right.
And that will be voted on by the commission in January. So I'm not sure what your question
So that'll be after January 1.
Right, it'll be
But
after
nothing's
January
going
1.
out. I guess nothing's going out until it all goes out together.
Yes, exactly.
Okay, I guess that's fine.
Okay.
Oh, that's it. Thank you.
Any other questions or comments from the commissioners?
Mr. Hatch,
Commissioner Hatch?
I'd just like to reiterate my cautionary comments to Aaron, the email that I don't want to see, looking at the flow sheet there, it looked like it was possible to adopt fact sheets and manuals before we adopt corresponding regulations. So I just want to make sure that we don't do that. We interpret the law with the regulations, then we adopt the fact sheets to provide clarification as to what we did. But I don't want to get in that situation where we adopted a fact sheet and then we got to modify what our regulations fit the fact sheet.
Commissioner Hatch, this is Erin. Yes, I understand that, and it's sort of a cart and horse problem. So we'll be monitoring that situation as the regulations are going through the interested persons process and going before the commission, and make sure that we're not duplicating any efforts, and at the same time balancing the desire to produce these materials as soon as we can. So I understand that direction.
Okay, any public comment on item 38? All right, thank you.
Can I just have a quick question?
Commissioner O'Darrow?
Sorry, just for my personal planning purposes, are we going to get all of this in one packet 10 days before the January meeting?
Are you referring to the manuals or the regulations or all of it?
Well, it seems like we're going to get a packet of regulations, which are on the first page, before the December meeting, and those will be voted on and approved, or maybe.
Are you on the interested persons list of the FPPC? Because you could get what goes out.
Yeah, I am on that.
So you'll get the initial version, so if you want to get a head start on it and see what we're presenting to the public, and then there would only be minor modifications to what actually goes on the agenda based on those comments.
Right, and the December list is already out. Those drafts are already posted on our website, and they've been noticed.
So just re-forward it to Commissioner O'Darrow again, so she makes sure she gets it.
Yeah, sorry about that.
Sure, no problem.
Okay, all right, thank you.
And the same will happen for the January package. So they will be, they are actually publicly available before the 10 days. Obviously, there could be tweaks made, but at least the initial staff drafts will circulate for quite a long time.
And then, so the January packet will have the regulations that are listed on page 2 of this document, and then all the website stuff, the manuals, the education outreach, and the additional legislation. No, that's going to come out in the February commission meeting. So January is going to be jam-packed.
Right.
Ooh.
Or you're off with a bang.
Okay, thank you.
Okay, thank you, Suki. All right, item 39 was more informational, just to have public notice that the ad hoc committee has been appointed. Commissioner Hayward is the chair and Commissioner Hatch, they both agreed to serve. I don't know if you have any update, Commissioner Hayward, on that?
Yeah, I just want to get people back up to speed about what we were thinking anyway. It's important to have principles that people understand, that are being followed, and that are clear. The principles that we're working off of right now were adopted in 2001. They're the same age as my high school sophomore. And nobody's prejudging that there's anything wrong with them, or just that we, as sort of a fiduciary responsibility of keeping this agency moving forward well, should be looking at them from time to time. So I encourage feedback from the public, as well as former commissioners and former staff of the commission. We think that it would be good to hear from people who have been in this operation in the past, just to see how practices might have changed, why certain practices were rejected. It's always good to learn the lessons of the past and not repeat them unnecessarily. So we're going to be doing this over the next few months and probably roll something back to the commission in the spring. Anyway, we'll look forward to a very educational and interesting process. Thank you.
And if you plan on having any public meetings, that will all be noticed and put out there, and we can actually even put it on the agenda as just notice if we decide to do that.
Yeah. Right now, we are trying to figure out the universe of people we can talk to, and that's where we are right now. Thank you.
Okay, thank you. Anything from you, Commissioner Hatch, on that?
Oh, just thrilled to be on the commission, on the committee. Thank you.
Okay, thank you. All right, executive staff reports, item 40. Any questions or comments from the commissioners? Commissioner Hayward?
Yeah, on the legal division report. So the Howard Jarvis ruling was dated August 23rd, but there's been no notice of entry of judgment. Is that correct?
Jack Woodside, I'll defer to John Fazer, who's working with the Attorney General. I think he does have an update.
Okay.
Commissioner Hayward, John Fazer, that was a long delay, but it came across last week. There was an entry of judgment, and the last day to file a notice of appeal would be January 12th, 2018.
Excellent, thank you. And
will we provide any further update in December as to whether we finally got it filed, what's going on, and that'll be on the agenda.
Thank you. And then I had another question under Burgess. The briefing schedule listed at the end of it shows that our opening brief would have been due by November 6th. I take it that was filed.
Yes, it was.
Okay. It's just when these are written as though it was written earlier, I'm like,
yeah,
that's very interesting. I wonder what happened. I think that's all I had. Thank you.
Any other questions or comments from the commissioners on the executive staff reports?
So maybe
Commissioner Odero?
Yeah. So maybe I'm behind the ball here, but I don't remember seeing the brief in Burgess. Did I miss it? Like
Jack,
I missed.
Sorry, Commissioner, Jack Woodside. In the past, we've tended to wait till we get all the briefs and then send them out at once. But if the commissioners would prefer to get them piecemeal as they come in, we can do that also.
I personally would.
Okay.
Yeah, more easily digested that way.
Okay, then we'll go ahead and send them out to the commissioners, or John will send out the opening brief.
Okay, thank you. Any other questions or comments? Okay, the reports will be submitted. And then the final item is just anything from the commissioners that they would like to have on a future agenda that has not already been discussed, noted, or talked about. And Commissioner Hayward?
Yes, Madam Chair. In light of the Bagley-Keene training last month, I would like to have on a future agenda discussion of whether or not it would be appropriate for us to solicit an Attorney General's opinion to help clarify some of the advice we got. We're looking at going into a packet of some, fairly significant regulations, although, there's not a lot of ambiguity in what the Disclose Act is requiring of us. I think there will be, at some point, some differing of opinion on how best regulate. I don't want the public to feel chilled about talking to me in between meetings, or you, or anybody. And I felt there was some vagueness in the advice we were getting that could lead to such a chill. And I also don't want inconsistent approaches being adopted by different commissioners. To the extent that advice was vague, that's certainly a possibility. I am aware under Garcetti that public employees don't have First Amendment protected right to free speech when they are engaging in official speech, but I'm not sure how that applies to us. And I'm not sure anyone else knows. I'm not sure the Attorney General's been asked that question, so it's been teed up for examination. And so I know we've got busy agenda with this month and the next with the regs, but I also think that having some clarity here is really important too.
Well, I would, yes, I'd propose putting it on December for, as you say, the first discussion so we could flesh out some of the issues and concerns that we can then come to a consensus on what we want asked, and then we can proceed from there.
Thank you.
Madam Chair.
Commissioner Odero.
So I am not going to be able to make it to the December meeting, nor will I be able to do it by phone because I'm in a mediation and it's a date that I can't change. But I would like to participate in this, coming up with a list of questions that we have for the Attorney General. So I'm not suggesting that we delay it and put it on the January agenda, but in what way can I participate in that absent, being absent in December?
I would not see any problem with submitting a written statement as to what your requests are, and we'll include that on the agenda with the discussion item, and it will just be noted that, that in your absence, you'd like these to be included in the discussion.
Okay, thank you.
Okay, any other proposed future items other than what we've already discussed and what's already coming up?
Yes.
Yes. Oh, I'm sorry.
Commissioner Hatch?
On Robert's Rules of Order, thank you for the copy that we received last month. On page 158, there's describes an informal procedure for small boards, and it's according to Roberts, it's boards under 12 members. Obviously, that applies to us, but there may be other requirements that would be in conflict with that, and I'd appreciate it if the extent that I'd like to find a way to clear it up. Perhaps we can have council review and just give us an opinion later as to whether or not we should follow that, or whether there are conflicting Bagley-Keene or APA requirements.
Okay, John's taking notes, and he will, and I would suggest if it's a question you have in particular, Commissioner Hatch, regarding the rules, I would start with just talking with John, and if you feel it's clear and you understand it, great. If you think it's an issue the entire commission needs to rule on or decide, we'll bring it back.
Well, just as an example, it says that motions need not be seconded. Our practice has been second motions. I don't know if we're doing that just because, or whether we think we're following the rules, or whether there's an APA or Bagley-Keene requirement that we do so.
I would have to look at the page you're referring to and the item. So if you don't mind, again, I think just because we don't want to get into a substantive discussion about Robert's rules and what the answers are, because this is just for future discussion agenda item, what would bring back. Again, I would ask that you start with speaking with John directly, and if you two decide that there is an issue that needs clarification, John will notify me and I'll put it on the agenda.
Cool.
Okay. Commissioner Odero?
Yeah, I would like for us to revisit the streamline schedule.
Right, that's on for January.
Oh, okay then. Very good.
Okay, anything else? I move to adjourn.
Second.
Commissioner Odero?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
Motion passes.
Thank you.
Yeah, it does. Well, I think it's stuffy too. You know, there's not a lot of air moving around. Yeah. Well, I can't believe how hot I got just walking over from the train station. Because it's not that cold.
No, but you had a
Yeah,
jacket.
yeah.
I feel like that always makes me super hot.
Yeah, because they don't really breathe.
Yeah, but even so, I mean, as it was happening, I was feeling like, come on.